Good morning. Thank you so much for being here. My name is Jenny Saul. I'm your program specialist with our community schools program, and I'm very happy to welcome you to our second Know Your Rights series. Today's series is on protecting your family and belongings in difficult times with helpful tips for preparing your family. We're going to go ahead and get started. I also want to thank you, all of our families, all of our SSAs who are in attendance. We have Trustee Estrella here. Thank you so much for being here. We also have Dr. Morris, our Director of Child Welfare and Attendance. We also have our Director, Rosana Fonseca, Director of SEL. And again, thank you to all of our community partners that we have with us here today. On today's agenda, we will be talking about creating a plan for your assets. We will be talking about naming guardians, discussing what exactly is a trust, and there will be some financial advisor support. There will be time at the end as well for questions. At this point, I would like to introduce to you Alex Varela with the Wagon Legacy Group.
Thank you. Thank you so much. Thank you for having me. My name is Alex Varela. I'm a local trust attorney and I own an estate planning law firm. And I'm just really, really excited to be here and to explain the best way that we can protect our assets and that we can protect our family. But before we get started, I would love to share the reason that I became an estate planning attorney. And that is because of my grandmother, Josefina. My grandparents came to this country from Cuba about 60 years ago, and they worked multiple jobs, worked really hard, and they managed to buy a little house. They paid $12,000 for the house total 60 years ago. As you can imagine, the house appreciated quite a bit in value, but my grandparents did not have a plan. My grandparents didn't have a will, they didn't have a trust. And my dad and his sister had a lot of conflict over how to take care of my grandmother the 8 years that she was sick, how much to prolong her life, and then what would happen to the one thing that they had when they passed away, which was their house. My dad and his sister stopped speaking to each other after my grandmother passed away. And unfortunately, right at the onset of COVID, my aunt passed away. She got sick at age 65, and she passed away about 6 days after getting sick with COVID. And it had been about 10 years or so since my dad had spoken to her, and 10 years or so since I had spoken to her. Something that I'm not proud of, something that my father's not proud of, and that we both wish we can go back and change. So now, the heart behind my practice is trying to help people avoid conflict and turmoil if something happens to them, and just helping families protect everyone they love and everything that they have. So this is for you this morning. And those are some pictures. Sorry, I forgot to move the slide, but those are some pictures of my grandmother, Abuelita. This is for you this morning if you're worried about needing someone else to help manage your assets or care for your children at any point in time if you couldn't be here. If you're worried about having to have someone run your business or pay your bills, or if you're just interested in making sure that what you want to happen will actually happen if you physically can't be present here with your family, if you become incapacitated, if God forbid you were to pass away, or if you needed long-term care. I also wanted to just on a personal note share a little bit about myself. My husband Steve and I have been married for 17 years, and we have 3 beautiful children. They are a huge source of inspiration to us, and they're a constant reminder that myself as a mom, I have to ask myself, okay, if my husband and I were not here to care for them, who would care for them? Who would we entrust to do that? and what's the best way to ensure that they are protected. And for the Cal State Fullerton photo is because for 2 years, I taught at Cal State Fullerton an estate planning class in the business school. I'm taking a break from that now, but that was a lot of fun. So it is very important to make sure that we've named guardians for our children, someone to care for them if we cannot care for them. Why? Because if we don't do so, then in some situations, perhaps a judge would name guardians. A judge that doesn't know us, a judge that doesn't know our family, a judge that doesn't know the family dynamic. There is actually a very famous case about a couple, Melanie and Casey Barber, and they were in a car accident in 2006. They both passed away, the mom and the dad, but the 3 little boys survived the accident. And multiple family members came forward to care for them. Aunts, uncles, family friends, and grandparents. There were more than 9 lawyers involved and thousands of court documents filed. The accident in 2006 was a Ford rollover accident. So as a result of the accident, the estate was awarded $22 million, which who knows, that might be one of the reasons that so many people came forward to care for the children. The court ended up placing the kids with an aunt. But the thing is, we will never know if that's what Melanie and Casey would have wanted for their children because they failed to name guardians. So the idea with this is taking matters into our own hands so the court or someone else doesn't have to make decisions for our family. In recent weeks, many clients have called the office and they are worried, right? They're worried about the best way to protect their children if they cannot be here. In our office, what we do is that we help people as part of their will and their trust and their powers of attorney. We help folks name guardians for their children. And it's called a guardian nomination. The documents essentially say, if at any point a child of mine needs a guardian, this is who I would want to do it. But if the client were to become incapacitated or pass away, someone has to file that with the court, file the nomination of guardian, file the will with the court, and then the court has to agree, which most of the time the court will appoint whoever the parents wanted, and then the court issues a court order and says, okay, these are the people that are going to be guardians for these children. And then the guardians would take that court order to school and wherever they needed, and they would have all of the same rights and responsibilities that the parents would. So that is called a legal guardianship. But there is also another form, legal form, that can be used, which is a caregiver affidavit. And a caregiver affidavit is more temporary and will allow a caregiver to make school-related decisions, like enroll a child in school, and medical decisions related to school-related medical decisions, and in some cases, if it's a relative, even broader medical decisions. This is definitely for temporary situations because with a caregiver affidavit, the caregiver might run into certain things that they're not able to do for the child. So if I was in a situation where I was worried about temporarily not being able to care for my children, I would make sure that I have both prepared, that I've named guardians if it ends up turning into a longer situation. I would ensure that guardians are named in my will, my trust, and my power of attorney. And we're going to talk a little bit in a moment about what those documents are. And then I would also make sure that my family, whoever might care for my children, has a caregiver affidavit and that I've spoken to them about what that form looks like, where it is, where they can find it, so that they have access to it. It's also incredibly important to make sure that our assets are protected. My practice is called the Wagon Legacy, And you might remember that on the first slide, there was a picture of a little red wagon. And that is because I tell clients that if you have no plan in place, it's kind of like you're walking around carrying all of your hard-earned assets in the palm of your hand like this. Something happens to you and it's kind of like you tripped and you fell and everything flies all over the place, and your loved ones have to go by trying to find every bank account, every retirement account, or life insurance policy. Often in that process, if our family doesn't know the details of everything that we have, it ends up going to the Department of Unclaimed Property. So basically, the state of California gets to hold on to it. But when we have a plan in place, instead of carrying our assets like this in the palm of our hand, it's as if we have this little red wagon and you're pulling it by the handle while you're alive and well. If something happens to you, it's like you tripped, you fell, you dropped the handle, and then someone that you know and that you trust comes and picks it up and continues to pull. But all of your assets stay inside of the little red wagon. That little red wagon is a symbol for a trust. So, and before we get to trust, many folks have heard of a will. And a will is a legal document that says who you want to leave your assets to if you were to pass away, and who you want to manage your estate. But the thing about only having a will in place that I think it's really important to know is that a will not avoid court involvement if something were to happen to us. So the best way to ensure that someone we care about can manage our assets if we temporarily can't be here, if we temporarily can't go to the bank, if we get sick and we become incapacitated, or if we pass away, is a trust. And a trust is going to be very important, especially important for us folks that, for example, own a home or have bank accounts. Like a will, a trust is a legal document. The key difference between a will and a trust is that, again, with a trust, nobody has to go to court. A trust is an agreement or a contract between the trustor and the trustee, and it's for the benefit of the beneficiaries. So the trustor is the owner of the little red wagon, the trustee is pulling by the handle, and the beneficiaries are standing around like the wagon like this. But while my clients are alive and well, you play all three roles. So you own the trust, you're managing the trust, and you're also the beneficiary of the trust. But for example, if you couldn't be here physically, or if you became incapacitated or passed away, the trust says who's going to be the successor trustee, which that means who's going to pull the wagon if you can't pull the wagon. So with a trust, you can essentially be pulling your assets in a little red wagon, and then I can say to my brother, here, brother, I can't be here temporarily. I just got diagnosed with cancer. I'm handing you the wagon. You pull it for me. You manage my assets. Make sure my mortgage gets paid. You make sure my kids have what I need. And then when I'm back in this country, or when I get better, or when I beat cancer, you hand me back the wagon, and then I will continue to pull. Most Americans, 80 to 90% of Americans, have a revocable trust. So one that you can amend, you can cancel, you can make changes to, and you can, as long as you're acting as the trustee, meaning you're physically present and able to manage the assets, you have capacity, you're alive and well, you can manage your assets in the same way that you manage them today. If you want to sell your house, you can sell your house. If you want to close accounts, you can close accounts. Everything remains the same. But again, the key benefit is that it's private. We don't have to go to court in order to allow someone to manage our assets. But a trust is not always enough. A trust is going to be used for assets like our home and our bank accounts, assets that are in the trust. We also want to make sure that, for example, if we were deported or couldn't physically be here, that we have a power of attorney. And a power of attorney says who can make legal and financial decisions for us if needed, who could pay our bills. If tomorrow I became incapacitated and the Edison bill is in my name, it is not in my husband's name, it is just in my name. If my husband Steve called Edison, Edison is going to say, we want to talk to Alex. And then when Steve says, well, Alex is in a coma, she got in a terrible car accident, they're going to say, well, you can't make any changes on the account unless you give us a power of attorney or a court order that says that you have the ability to make decisions for her. And that is my husband. And that's what they would do. That court order, if we become incapacitated, that's called a conservatorship, when you're appointed to make decisions for someone else by the court while they're incapacitated. It is very expensive. It is very invasive. So we want to avoid a conservatorship. And we can do that by making sure that we have a power of attorney. And literally every adult needs a power of attorney. My daughter just turned 18. She doesn't have a dime to her name, but she has a power of attorney because God forbid tomorrow, if she gets in a car accident, I want to be the person to be able to deal with Medi-Cal, with Social Security, to make sure she gets the benefits that she needs, to sign her name. I want to be able to sue people on her behalf if that's appropriate and if I need to. And then now that she's an adult, I don't automatically get to see all of her medical records because of a law called HIPAA. And I don't automatically get to make her medical decisions. So even though she doesn't have anything by way of assets, she still needs to have a medical power of attorney in place. I also wanted to speak about the best way to designate someone to make decisions for us if we couldn't be here physically, if we became incapacitated and want to pass or passed away. And many people are tempted to add people to their accounts, to add their adult daughter or their adult son to their bank account. And this is a really, really dangerous practice to get into, because once you add someone to your bank account, if the relationship or dynamic changes, it's really, really hard to get them removed. Not only that, but if I was on my dad's bank accounts and then tomorrow, God forbid, my husband Steve and I got divorced or I got sued, now I'm going to open up my father to a lot more legal problems if I'm on his account. And then with real estate, with our home, we definitely want to avoid adding people to title because it could have serious tax implications. Number one, it can change the property taxes. And I'm happy if anyone has questions about this after, I'm happy to answer any questions about this. And it could also mean that our kids could have to pay more in capital gains taxes in the future if we add them to the title. And that is, for example, if my father said, Alex, I trust you so much. I don't really understand what a trust is. I don't want to have to deal with it. So I'm going to make you a joint owner on my house so that if something happens to me, you already own part of it. If I do that, then I'm going to pay much more in taxes. And that's because let's say that my dad bought the house for $10 and now that same house is worth $1 million, let's just say. If my father passes away and I'm already the owner and I want to sell that property to, for example, split it with my brother, then I have to pay capital gains taxes from the $10 to the $1 million. But if I inherit the property through a trust, for example, then I'm going to get something called a step up in basis. And a step up in basis means I'm going to be treated as if I purchased the house on my father's date of death for $1 million, so no capital gains taxes. The capital gains taxes from the $10 to the $1 million gets completely erased. So I know that with the stress of everything going on, it might be tempting to add relatives or people to our assets, but it really is not the best way to go about it, and it could have negative consequences in the future. The better way to go about it is to have a power of attorney for legal and financial decisions and to have a trust. Because a trust, you can be the trustee, as I mentioned earlier, you can pull the wagon, and then you can sign a document called the resignation of trustee saying, I no longer, and it's a one-page document, I no longer want to be the trustee. Now I'm making my brother the trustee. And then my brother would manage all of the assets in the trust. He can sell the property. He can do everything that I would be able to do if he was on title with me, but I still retain legal ownership of the property, and I'm not giving my brother 50% and opening myself up to paying more property taxes or capital gains taxes in the future. So that really is going to be the best way to go about it and to protect our assets if something were to happen to us. Luis Gutierrez is also here. He's a financial advisor, and he's been a financial advisor for 12 years. And he can also speak to and answer any questions about best beneficiary designations or things of that nature if anyone has questions about that. But I'm happy to answer any questions, because we also want to keep in mind that having beneficiaries on our accounts is not always enough, because with beneficiary designations, remember that those only kick in if we die, right? But if we're incapacitated or if we couldn't be here, that doesn't mean that having a beneficiary doesn't mean that they're going to be able to access our funds or manage things for us. That's why we want to make sure that we're making the best decision for our assets and for our family. But I'm happy to answer any questions, and I know Luis is as well. Yes. Good morning.
I'd like to know about if I do the right thing right now to put him in my bank account for, whatever can be happening in the future, you know, uh, what you suggest.
Yes, I would suggest not adding your son to your bank accounts, because if, for example, I don't know if your son is married or single, but if, for example, he's married and he gets divorced, he has to tell the court what he has. When you go through a divorce, you have to list all of your assets.
Right.
He's going to have to report to the court, for example, that he owns half of your bank account. Or if your son were to get into a car accident and be sued, then his social security number is going to come up, right, with your bank account. So we want to avoid that because it can create many legal problems in the future. So it would be better to have a trust and to have your account owned by the trust. So for example, my bank accounts are owned by the Varela Family Trust, my trust.
Okay.
And if I couldn't be here, if I became incapacitated, or if I passed away, then because of what the trust says, my brother is going to be able to manage my assets. Another option would be to have a power of attorney, and the power of attorney can be effective when you sign saying it's effective now. So like, for example, if I were to be deported, I could sign something in 2 seconds and say, here you go, brother, now it's effective.
Mhm.
Or when I become incapacitated, or when I pass away. Because I met with a woman who her husband died of cancer. And when her husband was sick, they added their son to title. Okay. And then a few years later, her son got married, and not to the nicest girl.
Okay.
And he made a joke. He lives with her, and he made a joke to his mom about like, no, this is my house, mom.
Mhm.
And she came to see me and she said, Alex, total, I have 3 kids. I don't want problems between them. If I die the way it is now, the house is going to go 100% to my son. And I don't know if he's going to share with his sisters, and I don't want problems. So I want to do a trust. And I said, okay, well, now to put the house in the trust, your son would have to sign, right? She said, no problem. I'll bring him to the next meeting. You can explain it to him. He's a good son. I know he'll sign. Well, the son came to the next appointment with me and he brought his wife and he refused to sign. And I said, but wait a second, isn't this your parents' house? And he said, no, my dad gave me part of it. It's my house. And I said, that's funny. You were 20 when your parents put you on title. You probably didn't have a penny. But his wife has somehow convinced him that he's part owner of the house and that he shouldn't come off title. And it's sad. It's sad. Sometimes our kids change. The family dynamic changes. There's a lot to think about, but I would definitely caution folks from adding their children to title. It can have a lot of problems in the future for sure.
Okay, thank you. I have another question.
Yes.
For example, if I have a car in my name also,
Yes.
and I pay it right now.
Mhm.
For any reason, something happened to me, what happened to the property?
So cars are a little bit easier. Cars don't go through probate, and most cars can be or cars can be transferred through DMV forms. For example, when someone passes away, we use a DMV form called the Reg 5 form, and it's very easy to pass them. So, but with a power of attorney, if you were incapacitated, or for example, if I was deported, I could use my power of attorney. My agent, my brother, can also do whatever he needed to do for my vehicle as well.
Okay, thank you so much.
No problem, of course.
Hi, just
Hi.
curious, what is the average cost of a trust or a power of attorney, and where would people be able to go? Do they have to go to somebody certified, like a financial planner like you? Could they do it online? What is the best practice, or what is, I guess you could say the least cost or the most cost-effective way of getting something like this done, especially on a budget?
Yeah, absolutely. So for a power of attorney, a trust, a will, that is all considered an estate plan. And typically it's an estate planning attorney or a trust attorney like myself that will help folks with that. In my office, to set up powers of attorney for folks, like just the powers of attorney, it's around $500 or so. And then to set up a trust for someone, it's a little bit more complicated. And on average, it's around $3,500 or so. But that really depends on the circumstances and how complicated it is. There are certain situations that might make a trust more complicated. For example, if I have a special needs child and I want to leave them an inheritance, but when I pass away or when they inherit the assets, I want to make sure that they continue to receive Medi-Cal and SSI and things of that nature. There is a way to do that, but it's going to make the trust more complicated. So it really depends on the situation. But the best practice would be to have an attorney do it that can sit with you and just make sure that everything is done correctly. When clients absolutely cannot do that, there are instances where there are resources online, of course, and I would say that doing that is better than doing nothing. But the best case scenario would be to work with a qualified attorney to help you do that. A financial advisor is also super important, but the financial advisor is going to be someone that ensures that if you pass away, you have enough life insurance in place, that you're planning for retirement, that you know what you're doing as far as taxes are concerned, and that everything is set up in a way where if something happens to you, your family could manage the assets for you or inherit the assets. So I think both are super important, but it's definitely going to be a trust attorney that would set up an estate plan for folks.
So you just mentioned that we would be able to do it online. Let's say I don't have $500, but I do want to take care of this as soon as possible. And I definitely don't have $3,500 to go pay somebody to do this. What is the average cost to do it online? And do you have, can you give us an example of where we can go? Where online? Is there a specific website that you recommend if we were to do that? I know you just said it's better than not doing anything, but I know, like, if we just can't afford the 500 or the 3,500, what would be?
Yeah, unfortunately, I can't, for liability reasons, I can't stand behind a particular website because a lot of the websites are great. The problem is people don't know how to use them, right? So I've done many trusts for people that they already had a trust and they did it online, but they didn't feel comfortable putting their assets in the trust because they don't know what it says. And they tried their very best to read all of the options and select the right one. But sometimes they have kids and the trust doesn't even leave the assets to their kids. So I'm not able to say, yeah, use this website and do it this way because there's so many folks in the room and I don't know their situation or what their assets look like or if they have special needs children. There's just a lot to think about. So I would say, you know, it would be best to do some research online and look at reviews and things of that nature. Or you know, try to, we do at my firm, allow clients to pay in payments. And I know that helps a lot of folks, and a lot of folks with that as an option, they can find a way to prioritize the estate planning, right? Especially if we own a home, because if we own a home, in Southern California, it's going to be worth at least $500,000, right? So when we think about, you know, $3,500 to protect it, it really, the value is there. And I think it makes sense rather than using an online tool that we don't completely understand or know how it works.
Thank you.
Yes, of course. Yes.
Thank you. These are questions that I'm getting on my Instagram, so I'm kind of putting the platform out there. Questions I'm getting is, for example, majority of us may not own a house, may not own a restaurant. We don't have it like that. So big questions for some of us that are right now what we're dealing with immigration, right? With Trump. You may not be Mexican, you may be Cubana, Dominicana, or even Korean, Asian, whatever. You know, we're all in this together. I think main of the questions for them is, what if I don't have access like a house, a business? What I own is what I have in my back, my jewelry. So what are considered access for those people that don't have it like that? That's one of the questions.
So even a bank account, so anyone who works and has a checking account where maybe their paycheck is going there, direct deposit, they should have a power of attorney in place. Or anyone who has bills in their name, where, for example, the example I gave with my husband in Edison, right? If you have no assets, but you have a phone bill in your name and you might need someone to call Verizon Wireless for you, or go to a Verizon Wireless store for you, they're going to need to have a power of attorney. Anytime that someone is going to have to present themselves on your behalf and try to act on your behalf, they need to have a power of attorney in place, so that a difficult situation is not made worse by a lack of preparation, right? Because I think sometimes people say that, they say, oh, you know, I don't have any assets. Or for example, I had a case years ago where I did a woman's trust and her mom had come here from Mexico and she was taking care of her mom, and her mom had dementia, and she was here on a temporary status as far as immigration is concerned. Immigration, she needed to sign, the woman who was in her 80s needed to sign immigration documents, and she couldn't. And immigration told the daughter, well, you can sign for her, but we need a copy of the power of attorney. And she said, Alex, I didn't do a power of attorney for my mom. My mom doesn't have a dime to her name. She now passed away, but doesn't have a dime to her name. And we actually had to go to court so that she could be appointed so that she could sign the immigration documents for her mom, even though her mom didn't even have one bank account in the United States. So I think even if there are not a lot of assets at play, you should still have a power of attorney. And then it would just be a wise thing to do, because even if folks are not deported and they stay here, tomorrow you can become incapacitated and someone might have to apply for Medi-Cal on your behalf or deal with Social Security, do a whole bunch of different things. And if you don't have the power of attorney, it can become very problematic.
Another question on that. So for people that are dealing with situations like this, right? For I'm going to say we're Native Americans, okay? Because nobody's here illegal, right? On this land. So us natives, how is this trust, gonna benefit us, our community? Because I think that's one thing that they're here for. How is this gonna help them if, say, like you mentioned, what if my mother ends up leaving, I end up leaving with her, and my kids stay back? How is this gonna secure us? Basically, the most key here is we need that secureness and peace in mind that, hey, if I get deported, I know that, like you mentioned, my assets are going to be covered. My kids are going to be safe. How is this going to help us have some peace at mind right now that everything's going, what we're going through?
Yeah, well, it's hard to talk about people in such a general term, right? But for example, for yourself, if let's say you don't have any assets, but you have bank accounts, you might not need a trust, right? You might be okay with just having powers of attorney in place and naming guardians. And that's going to be a lot more economical to set up than setting up a full trust. But let's say that mom owns a home and mom has other assets, then she would need a trust and a power of attorney. Obviously, she wouldn't need to name guardians because she no longer has minor children. But the idea is making it so that someone else can make decisions for us. Someone else can go to the bank. Someone else can close an account for us. Someone else can write a check for us. All of these things that come up that we do in our daily lives that we don't think about, we need to make sure that someone else is going to be able to do that for us. But it does depend on the situation, and it does depend on what they have. So if someone comes to me and they have a bank account with $500 or $5,000, I'm not going to recommend a trust because there's just no real need for it. But if someone does have a business, even if it's a small business, if they own a home, things of that nature, then they are more likely to need a trust. So it depends on the situation.
So just to clarify, so what you're saying is if those that don't have much, it's okay to do what you're mentioning, the caregiver, right? Giving someone that rights to make decisions for that person not being here with the kids. The trust is more as in, hey, I have this property and I need someone to, keep an eye on that if I'm not here.
Kind of. So we have to think of it in like two different like columns. One column is the assets and the other column is the care for our children. For the care for our children, we can nominate guardians. Basically a document that says, hey, judge, if tomorrow I can't care for my kids long term, this is who I want you to appoint. Because when making decisions for the kids, with just having a caregiver affidavit, at some point, the caregiver is going to run into things that they're not able to do and they need a court order. So for caring for your children, we should name guardians, and that's a legal document that, for example, an attorney can help you with. And we should have a caregiver affidavit for the person that might care for our kids. And that is a form that you can get online, for example. So that's like for the kids. And that's anyone who has minor children. Doing those two things would be really important. And then for the care of our assets, or for someone to manage our assets, if you have a home and you have assets, then yes, a trust is very likely going to be required. If you have minimal assets, then you still want to have a power of attorney in place. And the power of attorney says who's going to be able to make legal and financial decisions for you if needed. So you can say, you know, your sister, for example, can make legal and financial decisions over your bank account or whatever it is that you have on calling your utility bills. Basically, be you if you're not able to do it. So two kind of separate things. But yes, if you have minimal assets, you likely will not need to set up a trust.
Mi pregunta es, yo tengo,
Her question is,
de,
I speak Spanish, thank
en
you.
mi
Go ahead.
trabajo tengo, mi aseguranza de vida,
Sí.
tengo por parte de mi trabajo y compré otra. Y aparte tengo para mi día, cuando yo muera, tengo también eso. Tengo a mi hija y a mis nietos. Si en grado caso que ella llegara a faltar, ¿qué podría hacer yo en ese caso? Porque son casi, en cada póliza, en la de mi trabajo son $50,000. Está ella como primaria y mis nietas, todos mis nietos. En la que yo compré son $150,000 y está como ella primaria y mis nietos. En mi seguro de vida, que es para cuando yo muera, también son $75,000. Está ella y todos mis nietos. ¿Yo qué puedo hacer para, si ella llegara a faltar o cualquier cosa, como dice, que ellas queden como, yo quisiera un fideicomiso, pero como decimos en México, fideicomiso de, que ellos, mis nietos, no puedan, otra persona estar más que ellos, pero sí que cuando tengan la edad, se les dé lo que a ellos les corresponde.
Yeah, bueno, qué bueno, señora, que tienes el seguro de vida. Oh, yeah, absolutely, sorry.
Different values, 50, 75, 150,000. And the main beneficiary is that her daughter and her grandkids. So she wants to know, in case that her daughter is not here or not able to be the beneficiary, what would happen to the kids? And in terms of the kids not necessarily inheriting the money of the policy right then, having somebody that will take care of them, but then when they are of age, that they could receive the beneficiaries of the policy.
Answer in English or in Spanish? Oh, in Spanish? Okay. Qué bueno que tienes el seguro de vida y que tienes a tu hija como la primera beneficiaria. Es cierto que como los niños, porque los niños no tienen 18 años, ¿verdad? No son adultos. Yeah, so, por ejemplo, yo también tengo un seguro de vida y no puedo tener a mis hijos como los beneficiarios porque mi hijo más chico, por ejemplo, solo tiene 6 años. So, Fidelity o Allstate, la compañía que tiene la póliza, no le van a escribir un cheque a un niño de 6 años porque él no puede firmar o confirmar que le dieron el dinero. So, en ese caso, cuando tenemos a niños en las formas de beneficiarios, el dinero tiene que ir por el proceso de probate, tiene que ir a la corte cuando fallece la persona y es un proceso muy largo y muy costoso. So, para mis seguros de vida, como el beneficiario, tengo mi fideicomiso. Y mi fideicomiso dice que si algo me pasa a mí, por ejemplo, yo estoy casada, mi esposo, él puede manejar los bienes, pero no puede cambiar los beneficiarios porque no quiero que se lo deje a la novia de 25 años, ¿verdad? Y eso, él no puede hacer cambios, pero él puede manejar el dinero y cuando él también fallece, va a ser para mis hijos y mi hermano se lo va a manejar hasta que mis hijos tengan 30 años. So, antes de los 30, si ellos necesitan algo, gastos de la escuela, gastos médicos, ellos se tienen que comunicar con mi hermano y mi hermano le tiene que pagar los biles. So, es la manera que pudimos a proteger los bienes. So, si como tienes los seguros, lo que sería lo mejor es a tener un fideicomiso y el fideicomiso, puedes a poner el fideicomiso como el beneficiario de la cuenta y el fideicomiso puede decir que primero va a ir a tu hija y si ella no está, va a ir a tus nietos en partes iguales, por ejemplo, y para qué se lo pueden dar antes de 30 y a qué edad se lo quieres a dar a su nombre. So, yeah, sería lo mejor.
So in a nutshell, The answer, the answer for that is because minors cannot receive, insurance companies cannot write checks to minors, and they cannot verify also they have received the money that has been inherited through those policies. What needs to happen is that they have to go through prorate. And as we know, probate is a very long, extensive, and expensive process. And so what she did was to put the beneficiaries instead of the grandchildren or her daughter, the living trust. And the living trust will specify that her husband is able to administer her assets, not able to change what she had already said on the living trust, but administer the assets. And then if something were to happen to him, the living trust will say also that her brother is the one that will be in charge of administering those assets and paying bills and so forth.
Yeah, thank you. Lucy, did you have anything you wanted to add to that, or? Okay.
Renovar, las tengo que cambiar para como fideicomisos.
Oh, yes. In many cases, when you name a beneficiary, you don't have to keep changing it. Once you name the beneficiary, it's set. When open enrollment comes, it's only if you want to change the amount of the life insurance policy or if you want to get more benefits. Is that accurate, Luis? Yeah, your beneficiary should stay the same.
Okay, gracias.
You also don't need to wait for the open enrollment to change beneficiaries. If you want to do that now, you can just call them and change the beneficiaries now.
Okay, we have a few more minutes for questions. So now's the time. We have our legal expert and our financial planner expert. We are on a campus, so our students are at nutrition right now. So we have about 5 to 10 minutes. Questions? And I apologize for running around with the microphone, but for the webinar's purposes, this is the only way they can hear us.
So I just, I know that not everyone has a home, but with rent and things like that. So let's say that like my husband and I were in a home, but the the lease is under my name, but I let's say I'm deported and my husband isn't on the lease. Would that be covered under, like, what kind of paperwork is necessary?
Yeah, absolutely. That is another aspect that can be handled by your power of attorney. So in those situations, I think just practically speaking, it might be a good idea to talk to the landlord and to get both people or everyone living in the house on the lease. That would be like number one to avoid problems, right? But if that's not possible for whatever reason, then yes, that is something that would be covered because the power of attorney is going to say that your agent, the person named to make decisions for you, they can deal with any contract, they can cancel any contract, they can re-sign any contract, they can deal with the IRS on your behalf. Anything. They could enter into all kinds of agreements for you. They could take out a loan in your name. All of these things, so many. I go to conferences and we just talk about powers of attorney and things come up that honestly I've never thought of before. But my colleague has worked with a client and this came up while the woman was incapacitated, or and it's things that we don't think of because life just happens, right? So, but yes, that is something that could be covered by a power of attorney.
So I just want to make sure I'm clear.
Yes.
So the caregiver affidavit is something that we've, really have given everybody.
Yes.
Gives families permission temporarily
Correct.
to enroll and do academic things
Mhm.
and medical things.
Correct.
Limited, but some medical things.
Correct.
And then the power of attorney gives someone the access to kind of act on your behalf, make contracts, cancel contracts, call Edison and Medi-Cal and Medicare and all of those things, sign for immigration things. So all of those things that are beyond in like school and medical, that's what someone would need to be able to access and
Correct.
kind of act on our behalf.
Correct. And then in the best case scenario, someone would sign a power of attorney. And then let's say that I bank at Bank of America. They would take the power of attorney to Bank of America, and Bank of America would pre-approve it and have it on file. And then they're going forward on your bank statement, you're going to see where it says power of attorney. It says POA on file. And that means that the bank is acknowledging that if you can't make decisions, you've already named someone that can make decisions for you. And this is way better than putting our adult son or our adult daughter on the account, because the POA, in a year, you can go into the bank and say, I'm revoking that POA or I'm updating it. And the person doesn't have to sign. But if I name my adult son or my adult daughter, and now the relationship with them has changed and they don't want to sign, or my niece or my neighbor or whoever, then I put myself in a legal mess. Yes.
Hi, good morning.
Morning.
So I have a question. My question is, the power of attorney is expire or it has forever? Because if I have 3 kids that are underage and they become adults, that I had to get a new power, or it's forever?
A power of attorney is typically going to be effective until you revoke it. So until you revoke it or you amend it. So for example, today you could have a power of attorney and you could name your brother or your sister, but then when your kids get older and they become adults, you might want to name them to make legal and financial decisions for you. So yes, you can amend it or revoke it, but in most cases, it's going to remain effective until revoked or amended.
Hi, good morning.
Hi, good morning.
So, I just want to make sure, once you sign or you have that one person, let's say you want to just leave it on, you don't have to renew any paperwork after that.
You typically do not have to renew any paperwork after that. So, for example, I look at plans with clients every 3 years, but like my husband and I signed the last update to our trust 6 years ago when my son was born. And that's it. I don't have to renew anything. If I leave here today and I get into a car accident and I'm incapacitated, the power of attorney says that my brother is going to do it, and it's already there, and he has a copy of it and he has access to it. So in that situation, the document says that to prove that I'm incapacitated, he would have to get a letter from a doctor, but then he would get a letter from a doctor saying Alex is incapacitated, assuming my husband is also incapacitated, and then he would be able to manage all my accounts and do everything for me. So it's definitely with estate planning, because laws change and family dynamics change and things. We want to look at it every, 3 to 5 years or so, but it doesn't mean it's not going to be valid, especially if we've already given the bank a copy of it. And that's why that's really a good practice, so that the bank has it. Because it makes sense, right? That if I give the bank the power of attorney in advance, if my brother walks in 5 years and says, hey, my sister, got deported, she's sick, whatever it is, the bank, they're going to be pretty standoffish if my brother's coming in with this document that I signed 5 years ago. They're going to be worried that it's fraud or that I didn't really sign it, right? They're going to be a lot more willing to talk to my brother if they already have a copy of it. And if I myself went to the bank and I put my power of attorney on file and I said, hey, Bank of America, if something happens to me, here's my POA. My brother is going to make my decisions. Bank of America is going to be like, oh, okay, we got it. And then when my brother comes in, they're going to be like, yeah, she told us about you, right? So we want to make sure that the POA is on file, the power of attorney is on file with the bank. That would be the best thing to do.
I heard over here. Do we have another question? Yeah.
If I choose to do the power of attorney and I have 3 children, do they all have to be, or do I need to choose one?
I think the best practice would be to choose one, because during a difficult time, a stressful time, sometimes it's hard. It's been my experience that sometimes it's hard to get three children to agree. So I think it would be best to choose one, and then the one who's making the decisions, the law says that they have a duty to the other beneficiaries, for example, if it's a trust or a will, they have a duty to keep them reasonably informed. So just because I'm in charge when something happens to my dad, for example, it doesn't mean that I get to do whatever I want. I still have to tell my brother what's going on. I still have to give him copies of bank statements. But that's better, because if not, if the three of them are forced to make decisions together, they might not agree on every little thing. That might hold it up. And then also just logistically, having three adults get to the bank at the same time with work and all of that can be really challenging. So I think to avoid conflict, probably naming one is the best. But to answer your question, you can, if you wanted to, name all three.
Steps in.
So let's say it's an example. They're married. They have kids with a different marriage, and the husband decided to put the beneficiaries, the kids. What's gonna happen to the wife that they're married, but there's not her kids?
So many times, if you put your beneficiary, it depends on the asset, but like on life insurance and retirement accounts, if you're married and you don't name your spouse, most of the time your spouse has to sign something called a spousal consent. And a spousal consent says that basically they approve of me naming someone other than my spouse as the beneficiary. But in that situation, I think that's why it's really important for couples to do a plan together, or for both of them to be on the same page, especially in those blended family situations where they both have kids from a different marriage. In that situation, like in order for someone to come in and do a trust with me and not leave it to their spouse, they would have to own the assets only in their name, like a house. Like if I had a house from before I got married, then I can put it in a separate trust, separate from my husband, and I could leave it straight to my kids. But for the house that I own with my husband, for example, as an attorney, I wouldn't allow them to like leave it to someone else. I know that's going to create a mess, so why would I do that, right? So I think that's the benefit of working with an attorney, is that I get to know the family and I get to know the dynamic and what their goals are. And I have dealt with a lot of that over the last 10 years or so, blended family situations. And I think it's really important to handle those situations with care, because most of the time, the person, they want to care for their spouse, but they also want to care for their kids from their prior relationship. And it is possible to do both. You just have to sit down and figure out a good plan for it, but it is possible to do both for sure.
Buenos días, gracias.
Buenos días,
Llegué
gracias.
un poquito tarde, pero quería saber para los dos procesos, cuánto cuestan, y dónde tiene que solicitarlos uno, y si para el de caregiver necesitan estar los dos papás presentes. Gracias.
Yeah. So el proceso, por ejemplo, para nombrar, English, I'm sorry. The process to name powers of attorney for legal, financial, and medical decisions in my office is about $500. And for example, my office is in Placentia, and then I also have a small office in Downey and in Irvine. But most of the time, we like to meet with people in person, but sometimes we also meet with people over the computer on Zoom or by phone. And to name guardians for folks, and even for the caregiver affidavit and who signs that, I think it does make sense for both parents to be present and to be in agreement to avoid conflicts and problems in the future. For sure, to name guardians for people, for children, I require that both parents sign it unless one parent is not involved, for example. Like if I have a single mother as a client and the father of her children hasn't been around for years and she has sole custody, then she can go ahead and name guardians on her own. But if both parents are involved with the kids and both have custody, then I'm typically going to want them both to be present and both to be signed to name guardians. And I think that's just to avoid problems. It's going to be the best way to go.
Thank you.
No problem.
Good morning.
Good morning.
I just want to make a little comment.
Yes.
This is for the community. You know it, that I was right here in Food for Less, like, I don't know, a month ago. And they deported this couple. They were here for 30 years, so here in the States, and they own a house. And I just want to let you know the community that we got to be careful. The ICE, they're going into the supermarkets. That's it.
Yeah, thank you so much.
It's me again. I have another question
Mhm.
about, it's not, my kids, you know, my husband and I, we've been separated for 7 years, almost 8 years. And, he's kind of ill right now. He not signed the divorce paper yet. So what can I do in case he pass away? And how can it be beneficiary for his, pension?
Yeah, so I'm not a divorce attorney. That's not my area of expertise, but I would definitely say, what did you say? He's what right now?
He's ill.
He's ill. Okay, okay. I'm not a divorce attorney, but I would see if you can get divorced without his signature and if that would be the best for you, because in most cases, it only takes one party to divorce. But yes, I would see about that because right now I'm working on a probate where the woman passed away and her sisters, her two sisters, thought that they were getting all of her assets. And the judge asked for her divorce decree. She's been divorced supposedly since 1982. I had one of my team members go down to the courthouse because those records are not online. Turns out she never got divorced. So guess who's getting her house in Chino? Yes. So that's why it's so important that we get divorced and we take care of these legal matters.
Yeah.
So I would speak to a family law attorney and I have referrals for that just to see what would be best. Now, if it wouldn't be best to get divorced because of his pension, maybe that's not what's best for you. Maybe it would be better to get legally separated and not divorced. But it would be important for you to have a plan in place because he's sick and incapacitated now, but if God forbid you passed away suddenly tomorrow, you're still legally married to him.
Yes.
So your assets would go to him. So that's what you want to plan for.
Okay, thank you.
And
Tengo una pregunta. Yo supuestamente, él hizo anuncio que yo me divorcié de él. Yo nunca he firmado el divorcio y no sé si eso es legal, que uno no firme, porque nunca llegó una notificación ni nada. No sé si ese proceso, ¿dónde podría verlo? ¿Y qué se puede hacer?
Yeah. Okay. Again, I'm not a family law attorney, but yes, there are ways for someone to get divorced and the other person doesn't necessarily have to agree to it. But that being said, you should have been advised and served with court papers. If it was recent, you can go online and you can search by name, or you can go to the courthouse and you could ask for the records in, for example, Los Angeles County or Orange County, wherever it happened, to see if you are legally divorced. But yes, I had another case years ago where a man lived with a woman for 40 years, but he was still married to another woman, and he passed away and the house was only in his name, and the house was going to go to the woman that he had not been with for 40 years. He had lived with another woman, and this was her house. She lived in it. And so she had to basically give a lot of money to the ex-wife, even though he was still legally married, to try to keep the house. And she did ultimately get to keep the house, but it was very expensive for her. So all of those things, it's really important to take care of that and to find out if you're legally divorced or not. You absolutely need to know so you can protect yourself.
Okay, I wanted to thank everyone for your time here today. I also wanted to thank Dr. Hammett for being here today. He is our Associate Superintendent of Human Resources. All of our community partners outside. If you do have more questions, we are going to be transferring over to the community center, but we will be ending our webinar right now. Thank you so much for being here. We'll have our third Know Your Rights series coming up in April. It's April 23rd, same place, same time. And again, thank you so much. Have a wonderful day.